We'll call the House Subcommittee number 2 on Privileges and Elections to order. We have 6 bills, I guess, on our docket this morning. I guess at least 3 of which we have technically heard, either similar if not identical bills. So we will probably limit testimony on ones that we have already heard. However, certainly we're going to take presentations from members one way or the other. We'll go ahead and start at the top of the list, Senate Bill 39. Senator Spruill.
Good morning, Mr. Chairman, to the committee. This is the second time that I brought this bill here, Mr. Chairman. It passed last year here, but was not signed by the governor, Terry McCullough. He didn't sign it. This bill simply adds party affiliation to the ballot for constitutional officers. Candidates running for these offices many times seek the party nomination, but then their designation is not on the ballot. Candidates who do seek party nomination will simply be listed as independent. With the absentees and early voting numbers at the all-time high, people voting do not have access to sample ballots to know who support which party. Mr. Chairman, you have heard all kinds of things as far as constitutional officers. For example, like constitutional officers, sheriffs and all, they were saying it was not good for them to do that because it takes sides. But it doesn't matter which party that you're on. When you hear a person run for governor, who you see supporting? It doesn't matter whether Republican or Democrat. Sheriffs, constitutional officers. So I live in Chesapeake, Virginia. So I said, well, let me look at my area where I'm concerned about first. Let's take the city of Chesapeake. The sheriff, Republican, Jim O'Sullivan, support this, saying, why would I have to spend money against a party nominee, win the nomination, then in November, I can't be on the ballot? He's a Republican. Let's take Thomas Fraternity, Republican, Chesapeake, same thing. Let's take the city of Norfolk, the sheriff, Joe Biden, a Democrat. Want to know why do I have to seek my party nomination? He almost lost the elections. He sought the party nomination as a Democrat and won, but on the ballot in November, his name was not there and almost lost. So why do I have to spend money to seek my party nomination and then yet I'm not? Norfolk, Commonwealth Fraternity, same thing. Commission Revenue, same thing. Portsmouth, City Treasurer, pays charity. Again, why do I have to seek the party nomination, win, spend all that money for a party nomination, and in November, I can't be on the ballot? So I put a name of saying that there are constitutional officers that get involved in all elections. All elections. As you have seen many times yourself, who the sheriff support, when they are not running, they pick a side one way or the other. So if they can do that, then why have them spend all that money to run for a nomination, but yet in November they cannot be on the ballot? I bought it, it passed last year, and trust me, Brother Blossom, it was not a party line vote, as you well know. So I brought it back, it passed last year, the House, and it passed the Senate last year, but the governor did not sign it. So I'm bringing it back again this year. That's my story.
All right, Senator. Are there any questions from committee members?
Yeah, I'd like to ask a question if it's okay.
Doug Williams.
Did the governor give any rationale or anything? Any indication at all, or just didn't sign it?
The governor? I think, well, you got some Democrats in here, so I won't say it. I don't think so. I'd rather not say. Well, he played the part. I'm gonna tell you the truth. He played the party line. He played the party line, and he was a Democratic governor. He played the party line, and I asked him, Governor, look at the votes. Look at the votes in the House and the Senate. It was not all Democrats. I had just more Republicans than Democrats when the bill got out of this House.
Look at Waxman.
Thank you, Mr. Chair. If I could ask the Speaker, maybe it's a Norfolk or Chesapeake issue, but I've had the majority of constitutional officers in my district contact me about not wanting that affiliation on the ballot because they like to be very neutral because they do work so close to the citizens. And and they've indicated to me this would be a hindrance to them performing their services.
Thank you, sir. Mr. Chairman, we heard that before, that sports like to be independent, but they're not. You have seen it on TV. You've seen it. I'm not too mean. It doesn't matter which party. They could kill us about that. But if they want to be independent, then why do they get involved in endorsing candidates who run for governor? Why do they get involved in those who run for the president? So if they want to be independent, then they should stay away from that. And then if they want to be independent, then why not run as an independent? Why do they seek your party in nomination? Doesn't matter which party. If they want to be independent away from everybody else, then why not run as an independent?
Delegate Bloxham.
Well, thank you, Mr. Chairman. I guess a comment and then a motion. I've never supported this type of thing. Most of mine, constitutional officers at home, actually go to both parties and seek their endorsement, not seeking the nomination, just because they want support from across the board. And all of mine, at least at home, are saying that they would rather stay away from this. So I make a motion to PBI the bill.
All right, motion made, properly seconded to pass by indefinitely Senate Bill 39. Members wishing to vote on the electronic voting board.
Sir, can I speak to the motion? Speaking of the motion.
Yep, Delegate Sickles.
I hope we will vote against PBI. I mean, I know this is a hard issue in some places, and people don't like democracy when it's messy, but once you go out and seek the nomination in any way of a party and then don't want to have the voters know that on the ballot, that's what pushes me over to the side to vote against this motion to PBI. Thank you.
Any further comments? All right, members wishing to vote on the electronic voting board. Clerk will close the roll. Senate Bill 39 is passed by indefinitely 5-2.
Thank you, Mr. Chairman.
Thank you, Senator.
All right, thank you.
All right, I think Senator Deeds came in with you next, Senate Bill 698.
Thank you, Mr. Chair. And this is a bill you haven't seen as far as I know.
Correct.
It's very simple, with just adds a paragraph to the end of the code section clarifying that anyone who receives access to the voter file can't publish it on the internet. Last fall, or after the election, I had a constituent contact me, and they sent me a screenshot of all their voter information that was on that some group, and I don't know whether, I don't recall whether it was a right-wing group or a left-wing group, but somebody had taken their voter information and published it on the internet. We contacted the Department of Elections, and they said it's not allowable. That we don't interpret that as legal, but candidly, there's nothing in the code that said it was illegal. So that's what this is about.
All right, any questions from committee members? Is there anyone here in the audience who wishes to speak in favor of the bill? Anyone in opposition? I know we do have one person online with no position from League of Women Voters, Ms. Berg. I don't know if she wishes to speak on this or not.
Good morning, Mr. Chairman. Can you hear me okay?
Yes, ma'am.
I am Pamela Berg, and I am speaking on behalf of the League of Women Voters, but not on this bill. So thank you.
Okay. All right.
Move to report, Mr. Chairman.
Been a motion made, properly seconded to recommend for reporting Senate Bill 698. Members wishing to vote on the electronic voting board. Clerk will close the roll. House Bill 698 is recommended for reporting 7-0.
Thank you very
Senator. All right, the next person I saw come in was Senator McClellan, Senate Bill 495.
Morning, Mr. Chair. You have seen a similar bill. I'm hoping you've had an epiphany since crossover. But this is a bill to reform our recall procedures. For elected officials, it does three things. It, instead of a 10% threshold for a recall petition of the voters in the previous election, it increases that to 30%, which is consistent with what the threshold is in other states. Rather than a court case, once you have reached the threshold for a petition, it has an election, a recall election, which is in line with other states. And then it changes the criteria for elected officials. It keeps, if you are convicted of a felony or found mentally incompetent, you still are automatically recalled. That's current law. But changes the criteria to get rid of what have been really vague criteria and leaves it at if you've committed certain crimes, which are current law, or if you have committed a crime against the locality you serve. And that's the bill.
All right, any questions from committee members? Delegate Bloxham.
Thank you, Mr. Chairman. Has there been a problem that we're trying to solve with this that you know of in Virginia? I'm just trying to figure out where the change in the threshold came from.
So there are a couple of folks who may be online who brought this bill to me. There have been an increase in some recall petitions here in the Commonwealth that cause them to look at our laws and the laws in other states. And they've recommended bringing this to bring Virginia in line with what other states do for recall petitions.
Delegate Bloxham.
And when you say other states, I mean, is this? I'm just trying to get a grasp of. I mean, who are we following here? I guess is the question.
I think Louisa and Jack, who are on Zoom, can tell you where they look. But they surveyed all 50 states to look at what their recall procedures were. And they can tell you sort of how many states follow this model. But we didn't want to completely rewrite the recall section, so we just took these 3 reforms to put us in line with what other states do.
All right, any further questions? Anyone in the audience wish to speak in favor of the bill? I think we have a couple of folks online. See, Dr. Boyarsky.
Yes. Can you hear me?
Yes.
Wonderful. So I am here representing the Virginia Grassroots Coalition, and Senator McClellan referenced the fact that we had been seeing a number of additional recalls in our area, and we wanted to make sure that the process was clear for everyone, both the people who wanted to recall elected officials and also those who might want to oppose it. And so we looked at all 50 states. 38 states have recall processes where it's the voters who get to choose whether an elected official is recalled. In Virginia, it goes to the courts. There's only one other state, which is New Mexico, where it goes to a court hearing rather than giving the power back to voters. And so one of the important pieces of this legislation is the fact that voters now get to decide whether somebody who is going through a recall process is ultimately removed from office. So we really recommend that power get returned to Virginians. And I know that Jack is also on the line, and he's going to talk about some of the other pieces of the bill that we think are really critical to make sure that it's a really transparent process, and it's a process that works, again, both for those who want the recall process so that we're clear on what the process is to do so, but also so that voters ultimately get the power to make the final decision.
All right, thank you. All right, Jack, I think she put you on the hot seat. Go ahead.
She sure did. Thank you, Mr. Chair. So when I'm going to talk a little bit about the signature verification process, which is, so I'm Jack Corelli. I'm from Fairfax County. I'm speaking on behalf of myself. And so when running for office, like everyone on this committee has done, you have to get signatures of qualified voters and follow a set guidance set by elect, and file specific forms and get everything through a very rigorous process. As you know, it's rigorous, but it makes sense. For recall and sort of these removal petitions, it varies from locality to locality. There's no set process for certifying that the proper number of signatures were collected. There's nothing sort of setting a overall like precedent for what this process looks like. Some clerks of court who this process kind of starts with require that the pages be verified. Some don't. Some weigh the number of boxes that are submitted. Some of them count the number of pages. It really varies from locality to locality. This means that when an elected official might be removed from office with the unverified signatures of less voters than the margin of victory and a receptive judge, which I don't think is fair. What we've seen is across the Commonwealth, this system has been used in different ways to really kind of confuse voters and confuse the system. I think we really need to take a strong approach and bring this sort of into the 21st century. I do also want to mention one other thing, the cost of this. There is a fiscal impact statement that I do want to point you towards that notes that there is no additional cost incurred to either the state or localities. And I'll go one step further as myself and say that localities will actually save money by taking this process out of the courthouse, where lawyers, no offense, argue these cases back and forth ad infinitum. And this brings it to the voters to directly decide that. So that's why I'm in favor of this bill.
Thank you. Is anyone here who wishes to speak in opposition? Last word, Senator.
Thank you, Mr. Chair. I think what I found most interesting when this bill was first introduced, there was a news article that I saw that had both conservative and progressive, both sides of the aisle basically saying that this would clarify the current process and make it more democratic. I think it really should be up to the people whether someone is removed from office and not a court. And that's the biggest change that this makes. And I also think that the threshold should be increased so that oftentimes 10% could be the margin of victory. Recall really should be used for egregious cases and not just when we disagree with the way you voted on something, which I know in some localities, literally if someone disagrees with your vote, I think in Portsmouth, if someone disagrees with your vote, they can initiate a recall. That's what the regular elections are for. But this really should just put the power back in the hands of the people.
All right. Any final questions?
I have a question, Mr.
Delegate Sickles.
Yeah. Isn't there supposed to be some bad malfeasance of law or something that is the justification for the judge allowing this? I mean,
It's pretty unclear. Right now it just says neglect, misuse, or incompetence with no definition of what that means and really no precedent as to what that means. So that's why you have these courts that look at this and say, does this rise to the level of an undefined term? It really should be for if you have committed a crime against the office or the locality that you serve, or if you've committed one of the crimes that we have already made it a public policy decision that you should be able to be removed from office. We should not have vague, undefined terms. And again, in some city charters, there are no grounds at all. And so I think this just makes it clear that it should be for a very serious offense, but still should be up to the voters and not a judge.
All right. Committee operates by motion.
Move to report.
Okay.
Delegate Bloxham.
Just going to speak to the bill.
Delegate Sickles.
Yeah, okay. I was hoping that maybe that if so I see I know where this bill is going, but this is a serious subject that needs to be studied. And I was wondering whether the majority would allow this to go by for the year under Rule 22 to look at this year and get us all educated on this important area of law. It is really fuzzy now, as the senator just said.
Delegate Sickles, who exactly would you have look at this over the next year?
Well, we are enacting an elections commission, Senator Vogel's bill, for a purpose like this, to send things and study them, like we have the Youth Commission, the Crime Commission.
Sure.
Yeah. That's where I think they ought to take a look at this.
And I would also note, Mr. Chair, that in the event that commission does not pass, we often will have joint subcommittees of whatever. So if we had a joint subcommittee of P&E, as a member of the Senate P&E Committee, I'd be happy to work with anybody on in the interim.
Okay.
Mr. Chairman, happy to do
Chairman Ranson.
that. Even if that commission bill does not pass for some reason, we're always happy to work on that into a resolution.
All right. Do you wish to
Parliamentary inquiry.
Bloxham?
So if I withdraw my motion but move to put it to a study, or do we just move to write a letter?
Say if you
Carry over.
carry it over under Rule 22.
Okay. Then my motion is to carry over to 22.
Yeah, so all those in favor say aye. Aye. Those opposed, no. All right, Senate Bill 495 is carried over under Rule 22.
Thank you.
Thank you, Senator. All right, Senator McPike, Senate Bill 222. I think this may be similar to a bill by Delegate Bulova, but maybe not identical.
That's correct, Mr. Chairman.
Okay.
It's a
Go ahead.
bill that requires electronic filing for candidates for all offices, except for those candidates that actually file under the exemption of local. If you don't spend $1,000 or less and agree not to take contributions more than $1,000, you have an exemption process in the code. So if you have soil, water, someone local, or a very small local office that they really don't have big campaign war chests like we're kind of used to, they have a waiver process. But everyone else above those thresholds would file electronically just like we do. So, I mean, all of us live in all parts of Virginia. We've been doing it for well over a decade. It just helps to increase transparency. If there's concerns about, connectivity across the Commonwealth, I suggest a delayed enactment date based on our broadband availability. But I think this is something that we've been doing for, I don't know what the timeline is, but well over a decade successfully for those who run for office in all parts of Virginia. So it's an important part of transparency, Mr. Chairman, understanding that I don't believe you acted favorably on the previous bill, but I think this is an important subject that its time has come.
Okay. All right. Any questions of Senator McPike? All right. Anyone here in the audience wish to speak in favor of the bill? All right. I think we have 3 folks on the line who wish to speak in favor. First one up, Ms. Morgan.
Thank you very much, Mr. Chairman. Nancy Morgan with the Virginia Chapter of American Promise. We support this bill, and particularly because of last year, nearly 7 million of opaque ads were funded, which were used to attack candidates of both parties. Some of you in this room today, and this bill introduced reporting requirements on all independent expenditures. So Virginia, 88% of whom support total disclosure, ask for your yes vote on this bill. Thank you very much.
Thank you. Ms. Berg?
Yes, thank you, Mr. Chairman. My name is Pamela Berg, and I'm speaking on behalf of the League of Women Voters. We support SB 222. All reports, regardless of office, should be electronic. Technology has developed over the years, making it easier to file electronic reports. Only by having these reports accessible on the internet can voters have the information they need to understand the contributions made to each candidate. Thank you.
Thank you. And Ms. Mott?
Yes, Jessica Mott, Arlington, Virginia. The Joint Subcommittee on Campaign Finance identified the need for this bill and approved it in principle. We ask for your support because it would strengthen disclosure by facilitating an electronic database, which is more comprehensive and can be more readily cross-checked through the algorithms for completeness and accuracy. And it would facilitate implementation of HB 492, which has already been you've approved, and the Senate is in the process of approving it. It's already been approved by committee. Thank you very much.
Thank you. All right, anyone wish to speak in opposition to the bill? Last word, Senator.
Happy Wednesday. It's good to see everybody. It's such a bright hour of the morning.
All right.
Substitute motion.
Delegate Williams.
Move to PBI.
There's been a motion made, properly seconded to pass by Senate Bill 222 indefinitely. Members wishing to vote on the electronic voting board. Clerk will close the roll. Senate Bill 222 is passed by 5-3.
Thank you, Mr. Chairman.
Thank you, Senator. All right, Senate Bill 463, Senator Bell. I think we had similar bills by Delegate Simon and Delegate Cherry earlier in session, although I don't think they're identical to this particular version, so.
Thank you, Mr. Chairman.
Go ahead.
They are not identical. This bill started out, I think, pretty much like the two in the House as a result of the Campaign Finance Joint Subcommittee, which met over the summer to try to study this issue. Over the years, I know we've had many bills in this subject area, frankly, by members of both parties. This is a really tough area to go into. I want to say that to committee as we get into it. And we took the bill that started off, we heard testimony, we worked with stakeholders again and worked with members of both parties, and we dialed the bill back in a few areas. So I want to just say to the committee, this isn't a perfect bill. It doesn't hit every area of campaign finance. It's a start. I think if we try to do a perfect bill, we're going to end up with more problems than we want. So to be clear, the things we've taken out of this bill, there was references to food, making that illegal, a candidate using food. That's a problem. If a candidate has a piece of pizza at the campaign office with their staff, technically that could be a violation. So we took any reference to food out. Clothing is another issue. If a candidate has a shirt with a campaign logo, wears a campaign shirt, that could have been a violation. We took that out as well. The other major difference was the guidance. The bill directs the Attorney General and the Board of Elections to develop guidance on this and to provide examples, which I think is going to be very helpful and good. But it directed them in the enactment clauses originally to look at the federal laws and use that as a guide. We took that out. There are a couple of issues. There's some good examples in the federal law, and frankly, some of them mirrors what we have here. But one of the, I think, real problems with the federal law is it allows a candidate to pay themselves the salary of the job that if they were to win while they're still a candidate. And I think that could be a real problem. So we took the federal part out as well. And we've just basically stuck with what we consider to be the low-hanging fruit, the things that are the most egregious. Lastly, the other thing we did is on the illegal areas, it covers school, or rather education by the candidate. And you'll note we addressed that where a candidate could actually, before it was designed really where a candidate couldn't pay tuition for their family members, which I think we would all agree is pretty egregious. We've amended it where a candidate could use it for professional development, or a member serving with a campaign account for professional development as it relates to campaign legislative training. So you could, if you went to Sorensen Institute, you could pay for that. You could pay for any kind of a candidate training. You could pay for a college class in a subject area. Perhaps you were serving as a legislator and you want to improve your knowledge. So we wanted to take those type of things out. There are a lot of provisions in the bill that cover false type of claims to try to make sure that there's protections. At any time, if the only people, first off, who could put in a complaint of misuse would be someone who could vote for the person or somebody who gave to the candidate, one of the two. And then the candidate has to be notified immediately, and then there's a process to go through. At any time during the process, the candidate could return the item or pay back the money, and the investigation's closed. So that's a good protection. There's other protections for false claims as well. And if someone does a false claim, they can't make another claim. The idea here is not to do got you type complaints. It's really to hit the most egregious things. The last thing I'm going to mention is I really believe this in my heart. The people here in Richmond, I think both parties, we all come here to do the right things. And frankly, I don't think the biggest abusers of personal use are people who are serving here in Richmond. The biggest abuses I've seen are candidates who lost and still had large amounts of money in their accounts. And this would protect us against those instances as well. I think a lot of our focus is only on people who are here. It doesn't cover, or we think about people who may have run and lost, but in many cases, they have large sums of money, which could be abused. So with that, Mr. Chairman, I appreciate your time, and I'm happy to thank or answer any questions the committee I have.
All right, any questions of Senator Bell?
Yes, sir.
Delegate Taylor.
I see child care is included as something that's as an appropriate use of campaign funds. This is a position of public service, and my spouse is sacrificed, families are sacrificing, and if you have children that need child care, I do not think that should come out of campaign funding. That is a personal expense. It's something that you go into your campaign knowing that you're going to have to make arrangements for. So I have a real issue with that.
Mr. Chairman, I hear the concern. I think it's a good concern. In line 361 of the bill, we've got that it's not, the contribution or the money in the campaign account is not meant to pay for any expense that would exist irrespective of the person seeking, holding, or maintaining public office. So, and we give examples, and we also are asking the Attorney General Board of Elections to give more examples. The child care portion was meant for a volunteer who's serving in a campaign and or to come in and serve in your office as a volunteer to cover their child care. I'm happy to clarify that language more, but the irrespective language would mean if you have a child and you're serving in office, that's an expense for child care you would have if you work any job, and it shouldn't cover that. But I'm happy to address that because I don't want any misunderstanding that you should be, for instance, elected or hold the office and pay your child care, because that's certainly not intended.
Well, if I heard you correctly, you said a volunteer's child care expenses? So again, I mean, it's a volunteer. They know what time they need to be there, and they know their child's schedule. That, to me, is just, it's not a proper use of campaign funding.
Mr. Chairman, I hear your point of view. On the volunteer issue, I will tell you that the working group looked at that and felt that many people who wanted to volunteer and work for campaigns of both parties were held back by this issue. And that's why that was included in the bill. Again, I'm not looking for the perfect solution because I'm not sure we can do the perfect solution. And frankly, if I'm looking for a start, and sometimes we have to do that in very complex areas, I would be willing to strike that line if it moved the bill forward, if that were the committee's will.
Delegate Bloxham.
Yes, sir, Mr. Chairman. Question. So the way I'm reading this, other than some other issues, like Delegate Taylor said, that line 366 and 367 about who a person that believes a violation has occurred. So if someone contributes $1 to me, then they can lodge a complaint no matter where they live, is the way I gathered this. And then if someone lives in my district that doesn't support me, can file a complaint. Am I correct with the way I'm reading this?
Mr. Chairman, the gentleman is correct.
All right. Delegate Munden King.
Thank you, Mr. Chair. I have a comment and a question. So with all due respect to my colleagues, I could not support this without including dependent care. And I really appreciate you including dependent care and not just child care. And just to speak to that really quickly, I think the federal government does allow child care expenses. So in 2022, to be running alongside candidates, working moms, working dads, people who are not independently wealthy, and for one set of candidates to be able to use this expense, and then another set would just doesn't, because I do believe this is allowed for federal candidates. And just to speak to the barriers that it creates for working people to run for office. And we all look at VPAP and we know the disparity in this body of the independently wealthy, the very wealthy, and those who are able to afford to run and to serve in this body. There is disparity, there's racial disparity, there's gender disparity. And being someone who was here 20 years ago and seeing the makeup of the body and being here now and seeing the diversity, not just in race, but in people of all walks of life, it makes us stronger. So if we can eliminate barriers, and money is one of them, and follow federal guidelines, I really don't see the problem with that. To my question, which is unrelated, you mentioned that the guidelines would be developed by the Attorney General's office, and I was just wondering why that. This is from the non-lawyer caucus. Why versus the campaign and election folks, or would they work together?
Mr. Chairman, the guidelines would be developed by the board and the Attorney General. And I think it's important the Attorney General be part of that because there's an enforcement issue. So we need to make sure that the Attorney General is involved. Also, we've asked for specific examples. again, this is complicated, so I would say, as far as the child care issue, I hear your point. Frankly, my personal worldview is helping someone to participate in the process. If covering child care does that, I'm fine with it. But again, we have nothing today. There's nothing to stop anybody from, frankly, doing anything they want with these funds. So I'm trying to establish a start. It won't be perfect, but it will take care of the most egregious things. And frankly, when a candidate or an elected official does one of these most egregious things and hits the paper, it makes all of us look bad. And I think it hurts the trust that people have, because people should know we're here to serve, to do whatever our heart leads us to do in service to the Commonwealth, not to enrich ourselves.
Delegate Ranson.
Mr. Chairman, Delegate Bell, Senator Bell, sorry. I've heard you say a couple of times, this is a start, this is a beginning. I'm personally am uncomfortable putting something in code that's a start that several members are, and we've had some folks on the other side too vote against when it's not perfect. And a couple of times you said this morning, it's not perfect. Putting something in code that's not perfect, that's not just right, I feel like is wrong. We established a work group. My understanding is that the work group never came to a consensus together collectively on legislation and voted collectively as a majority to put something forward. I agree with you. We probably need to come up with some guidance and some guidelines. We did pass a bill out, I believe, Delegate Bulova, to move forward with the work group again. Maybe this could be a starting point that we could collectively begin working forward. So obviously I cannot vote this morning, but I just wanted to offer those comments to the
Mr. Chairman, what I would say is, I hear what you're saying. I mean, frankly, I wouldn't normally go for a solution that isn't perfect. And I don't want to jinx his bill. My friend, Senator Hanger, has a bill where he's trying to cover agritourism on farms with structures. And it reminded me very much of the same situation. He's trying to get a start with something where it's really a difficult area. And on this one, I will tell you that we've tried to take out the most problematic things, because the intent is not to catch a candidate with frivolous complaints. And I don't want, to your point of a $1 donation, I don't want a ton of frivolous complaints from either side, and I think that would be terrible for the process. Trying to get rid of the most egregious items. This did pass the Senate 37-3. Senator Norman spoke on behalf of the bill, and his comments were, he was part of the working group, was that this isn't perfect, but it's a really good start, and we need to start somewhere. So, I mean, if it's the will of the committee, I'll certainly continue to work on this. But I will say, I think it's going to be hard at any point for us to get a perfect solution in this area. And I think that's why the guidelines are so important, because there's a lot of gotchas.
Delegate Maldonado.
Thank you, Mr. Chair. Just speaking to the bill. I just want to say thank you for putting the good work in here. I am very concerned about this issue and what we see across our kind of campaign finance world. I think that we put bills in with much respect and deference to Delegate Ranson. We do put things in that are good starts. But in this particular case, I just want to say thank you, acknowledge the good work, and I think there are some places here that we do need to tighten up. I don't want perfect to be the enemy of good, but what I do have concerns about is that I think child care should be included, but dependent care as well. Think about many of us are in the sandwich generation. We're caring for ailing parents and children at the same time, and some people don't have children at all, and they're just caring for ailing parents and have that responsibility. In order for us to remove some of those barriers, I think we have to kind of go through it a little, parse it a little bit more carefully. I would love to work with you on this going forward if this doesn't move forward at this time, because I think this is very important, and I think people need consistency. We need guidance so that we can have a standard of care and ethical duty that everybody follows. I thank you. Thank you,
Mr. Chair.
Delegate Taylor.
Make a motion that we table this bill.
And a motion made, properly seconded to table House Bill, or Senate Bill 463. Members wishing to vote on the electronic voting board. Clerk will close the roll. Senate Bill 463 is laid on the table by a vote of 5-3.
Mr. Chairman, I thank you. I thank the chairman. I appreciate your time and on this very difficult bill. Thank you.
I think Chairman Ranson will be back in touch. All right, last bill on the docket, Senate Bill 318, Senator Favola.
Good morning, Mr. Chair and members of the committee. Senate Bill 318 addresses the requirement for third-party organizations to actually disclose their top donor during a campaign season when they come forth with an ad, either to influence a referendum or to influence the outcome of an election between candidates. So it's very straightforward. There's no burden on the individual candidate to report. It's all third-party reporting. And again, it's considered a election communication if it's 30-day, if it's done 30 days before primary or 60 days before general. And this bill covers all venues of advertisement, print media, print, television, social media. And the top donor would have to be disclosed, and that's it. This bill is, I understand, is identical to Delegate Helmer's bill, which perhaps you didn't like, but maybe you've had time to think more about it. You might like mine, even though it's identical. Delegate Helmer's bill was House Bill 489.
All right, any questions of the senator?
One other, may I?
Yes,
I apologize, but this topic was discussed actually at length on the Joint Committee on Campaign Finance Reform, of which I was a member, and you were too, Mr. Chairman. So this had a bit more vetting than you would normally expect from a proposal coming forward without having a committee behind it. That concludes my remarks.
All right. Any questions, Senator?
Mr. Chair.
Delegate Williams.
Senator, my grandmother is my top donor. She loves me dearly and is very proud of me. Would she have to be?
She would not.
Okay.
No, she would not.
Okay. All right.
Your grandmother would be listed, I expect, when you disclose your contributors. Right. These would be, you raised a very important point. This would affect organizations that do not coordinate in any way with the candidate or a referendum question. So these are third-party entities coming in on their own, not coordinating with the campaigns. Thank you for asking that question. I should have made the point earlier.
All right, any further questions? All right, committee operates by motion. I think Delegate Ransom beat you to the punch, but I didn't hear your motion. Okay. Been a motion made, properly seconded to table Senate Bill 318. Members wishing to vote, please vote on the electronic voting board. Clerk will close the roll. Senate Bill 318 is laid on the table by a vote of 5-3. Thank you, Senator.
Well, I appreciate your attention to this matter. Thank you.
Sure. All right, being no further bills before the committee, we're adjourned.